Yes. As we start, we look for the definition of a director. Section 2.1 states that a director includes any person occupying the position of director by whatever name called. You realize that is not a definition of who a director is. But judicially, a director means one or another or two people responsible for the directing, governing, or controlling the policy or management of a company. You'll remember that we have said the directors are very important. They run the day-to-day. They are given the mandate to ensure that the company is operating, the company is making profits, the company is meeting its obligations, the reason as to why it was formed. So the articles of any company, again, will be used to designate who its directors will be. And therefore, the directors are the brain of the company. And since the shareholders, you remember for a public company, more than the members, they can not all be involved in the day-to-day running of any company. This is why they delegate that power to these directors that we are talking about. And we talk about the legal position of directors. And we are doing this because, as you have seen, the Act does not clearly say who is a director. So we define them as per their roles in that company. So we talk of a director as an agent. And as an agent, the director acts on behalf of the owners of that company. The company itself, despite it being a legal entity on its own, cannot act on its own. It cannot act on its own person. It being a separate legal entity from the members still requires the human aspect of the day-to-day. And therefore, directors become agents of the company. The company is the principal, the director is the agent. And whenever an agent is liable, a director is also held to be liable. And where the liability is to the principal, the company is liable as the principal alone. So as agents, directors must conduct the business with reasonable care, due diligence, and abide by the memorandum and articles of association. Because it is this memorandum, the coexistence of a company is based on the memorandum. So why does a company exist? The memorandum sets that out. We talked about the articles. The articles bind the company to the members. So the rules set out in the articles of association, again, must be upheld by the agents. And since they're the ones who enter into contracts on behalf of the company, when they put their signatures on behalf of the company, they bind the company. And we use agents in not in its strictest term, because directors are elected. You remember when we talked about meetings, we have the AGM where a director may be re-elected or the term may have lapsed and they have served the number of years that the articles provide. But you see, agents are appointed. And directors may not be rewarded but are remunerated. And the difference between a reward and a remuneration is that they earn their their stay. They earn their keep. They earn their job. Again, agents are entitled to commissions as per any agreement or that appoints them, and this is their reward. But directors are not entitled to a commission. Their remuneration is set out, and there is no further percentage they are earning because of conducting their business. We also have directors as managing partners, and directors are elected representatives of the shareholders. Therefore, they manage the affairs of the company. And in most private companies, limited by shares, these directors are required to hold share qualifications that makes them partners with the shareholders. And they are bestowed with the powers of allotting shares, making calls, forfeiting of the shares, and others. But directors do not have the authority to bind other directors and shareholders like in a partnership. And you see, in a partnership, we discussed that the actions of one partner can bind all other partners. This is not the case for directors. They can only bind in as the powers have allowed them to. And the fact that they retire means they are not strictly speaking partners. We use these terms to try and identify how directors, how do they operate. So the essence of them being managing partners, so to speak, it is in as far as the affairs of that company take place. It is not a lifetime appointment, and neither does it mean that once elected, because they are not appointed, once elected, they hold their status to perpetuity. We also talk about directors as trustees. And the reason we will call them trustees is that they act for the benefit of the company and not for their own interests. And where they have seen to be acted in their own interests, such contracts, if entered into, such activities that have been entered into, they may be set aside. So this element of trusteeship is that directors stand in a fiduciary position. And you remember we talked about a fiduciary position. This is where you act in utmost good faith. Your intentions and your actions match for the benefit of this company. And where they have acted in ways that the company loses money, they have been held liable. In York versus Hudson, directors who had improperly dealt with funds of the company were to reimburse this money. And directors, it was held that directors are called trustees over the assets which they are in possession of on behalf of the company. Anything that they hold on behalf of the company, what they control on behalf of the company, cannot be misused. And we say that although directors are not, properly speaking, trustees, they've always been considered and treated as trustees of money, which comes to their hands or which is actually under their control. And they are not trustees for the shareholders or third parties who deal with the company. They are trustees for the company itself. And again, we will try and differentiate in the strict legal sense. A trustee is the owner of the property. But in this case, We will use trustee in a broader term, that of a fiduciary element. We don't use it in the strictest terms of the law, because a trustee can own that property and deal with it in whichever manner that they please. But for the company, you can only do so in as far as the articles of association provide.